last matter to come before the court this morning is James Ponyicky versus Crystal Schemrich. Gentlemen, both sides only 15 minutes to present oral argument. The appellant will proceed first and may reserve up to 5 minutes for rebuttal. And if you'll let me know how much time, if any, you wish to reserve, I will be keeping time. We've read the briefs. We're ready to proceed.
Thank you very much, Your Honors. May it please the Court. My name is Kenneth Fisher, attorney for Appellant City of Brunswick, and I would like to reserve 5 minutes for rebuttal, please. Thank you. In 2009, the City of Brunswick, by and through Brunswick Transit Authority, BTA, entered into an agreement with Medina County Public Transit for the provision of drivers for the city's fleet, and I use that word somewhat loosely, of 3 buses that provides transportation to a small segment of the population in Brunswick, and mostly comprised of elderly and infirm. As part of that agreement in 2009, which is still in effect, it's the city's responsibility pursuant to the contract to perform maintenance. The city in 2009 entered into an agreement with George Rayak, an independent contractor, to provide maintenance and repair of the fleet of 3 buses. The incident that gave rise to the complaint occurred on May 22nd, 2010. It was an accident, and clearly just an accident. The driver of the bus, actually employed by the Medina County Public Transit, Crystal Schemrich, named as a defendant in this case, followed all procedures as it related to the inspection of the bus prior to commencement of her route on that day. The uncontroverted testimony is that as part of the pre-inspection that she performed, there were no issues at all with the brakes or what's known as the engine retardation. What happened is clearly unfortunate and an accident. There was 1 passenger on Crystal Schemrich's bus that day. The engine retardation, which is when you take your foot off the gas, the brakes will automatically begin to engage, according to the uncontroverted testimony of Crystal Schemrich, did not work. She was able to pump the brakes several times, and the brakes did engage, causing the bus to go into a skid and made contact, and I mean minimal contact, with the plaintiff appellee's vehicle. There was no damage to either vehicle. In fact, the plaintiff appellee got out of the vehicle. His vehicle apparently had a prosthesis on his leg and moved that, and became very irritated with the bus driver. Neither here nor there, but no damage to the vehicle, and again, not an issue for today as to what his personal injuries are. As
I thought from the briefs that there was some damage alleged to the vehicle that was rear-ended, but none to the bus.
Minimal, Your Honor. In fact, what happened here is 3 weeks later, Mr. Ponyicky, the plaintiff appellee, is involved in a more significant accident completely unrelated to the City of Brunswick, which is also joined in this lawsuit. So we have the accident on May 22nd, and then we have a subsequent accident 3 weeks later, not involving the city, that's also part of this lawsuit. And again, damages are not an issue, and I won't go there. What happened on May 22nd was that George Rayak, the independent contractor hired by the City of Brunswick to perform maintenance and repair, actually came out to the scene. He was there. He came out. His uncontroverted testimony was...
Wait a minute, is this the independent contractor?
Yes, but employed by the city that performs maintenance and repair. He came out to the scene immediately after the impact, again, which was just an accident. I mean, there's no question that every motorist has to maintain an assured clear distance. That didn't happen. So that's not in dispute. What's in dispute is count 2 of the complaint as it relates, and I'm sorry if I'm maybe going around in a circle here, but it's really 274402B, and the fact there is no exception to a governmental immunity for the proprietary function that the city was performing. And that's really the issue today. Is there an exception to governmental immunity as it relates to count 2 on the maintenance and repair of the vehicles that were, by all accounts, properly performed by the City of Brunswick through its independent contractor? No testimony, no evidence whatsoever that any employee of the City of Brunswick, and that can include even the independent contractors and Crystal Schemrich, who was the bus driver employed by Medina County Public Transit, did anything at all that could even remotely be considered negligent as it related to the maintenance and repair of the vehicle that was involved in the accident. And so that's the issue.
But isn't that specific question one for the jury?
I don't believe so.
Whether there was negligence? Not
in terms of the operation of the vehicle. No, in terms of the maintenance and repair, I think that's a question for summary judgment. I think there has to be, the burden is clearly on the non-movement to show what the exception is. I mean, that clearly is the law. I mean, there's governmental immunity under 2744 for governmental and proprietary functions. There has to be an exception under 274402B, and in this case, the only applicable of the 5 that would apply would be 2, which be negligent performance of acts by employees of the city with respect to the proprietary function of providing the bus service. And again, there's no evidence whatsoever that the plaintiff appellee has been able to present to establish that there is an exception as it relates to the maintenance and repair of the vehicle in question that was involved in the accident on May 22nd. The testimony of George Rayak, the gentleman, independent contractor responsible for maintenance and repairs, is most important. And
is there an issue as to whether or not Mr. Rayak is actually an employee versus an independent contractor? Is there an issue of fact that remains or was debated at the time when summary judgment proceedings were underway?
I think it perhaps was an issue, but for purposes of argument, in other words, the city did engage him. Is he a PERS employee? No, he's employed as an independent contractor. But again, the responsibility, contractual responsibility, Your Honors, and it's a very good question, is that of the city, so I don't believe that's an issue. We're contractually obligated under the 2009 agreement with the Medina County Public Transit, the acronym MCPT, to do the maintenance and repairs. So whether we employ an individual to do that or use an independent contractor, it's our responsibility, no question about it. And on the day of May 22nd, the pre-test was done by the driver, again employed by the county, and that was another issue that ended up in this court as to whether Crystal Schemrich was in fact employed by the county or the city. Be that as it may, the city's responsible, okay? And so there's no issue there in terms of the first count. It's only the second count. And again, when George Rayak came out, the smell and heat level of the brakes indicated normal brake operation. There's absolutely no damage to bus T-12, which is the city bus. He had the driver perform an air brake leak down test at the scene, which passed without issue. The driver advised there were no issue with the brakes prior to the date of the accident. He'd never had a situation in 35 years where the engine retarder was not operating and the brakes were not functioning at all. He'd never experienced anything since when he gave his deposition testimony. That he drove the bus T-12 back to the garage, and that's at City of Brunswick Municipal Complex on State Route 303. There were no issues with the brakes or engine retarder that he noticed. That he contacted all drivers who drove bus number T-12 the week of the subject accident, and all drivers reported that everything worked fine and absolutely no problems with the brakes.
So was Mr. Rayek's testimony in direct contravention of Ms. Schemrich's testimony then, with respect to the engine retarder?
No, there's no question that, we're not disputing that. I mean, the question is, was the city negligent? In other words, was there, or put it this way, is there an exception under 274402B2 that allows immunity not to apply? So I don't think there's any question that there was a breach of assured clear distance, that the retarder didn't work. But again, the question is, what did the city do in terms of breaching a duty owed, okay, to the public in regard to the maintenance and repair of this bus, the T12? And I say that there is no evidence whatsoever that the city was negligent as it related to the maintenance and repair of the vehicle, which is count 2.
And you have reached your 5-minute mark if you want to reserve time.
I do indeed. Thank you. Thank you much.
Thank you, Your Honors. May it please the court, my name is Paul Knott. I represent James Ponyicky in this action. There are a ton of questions of fact concerning the maintenance of this bus. 2 months earlier, there was a massive air leak on this bus that was repaired by Mr. Rake. Mr. Scafidi, the service director for the city of Brunswick, had testified he was aware during this period of time there were a number of problems with the brakes on the buses. Crystal Schemrich has testified, and it's uncontradicted, what happens when you take your foot off the gas on these buses, the retarder engages and the bus begins to slow. Then you put your foot on the brake. She said she took her foot off the gas, the retarder did not engage. She then pressed down on the brake 3 times, the brakes did not engage. She told the passenger in the bus, brace yourself because we're not stopping. The bus continued on and struck the back of Mr. Ponicky's vehicle. She remained in the car, she was upset, she remained in the car until Mr. Rake came. There are clearly questions of fact as to whether or not the brakes on this bus failed. If the bus brakes failed, it's very clear in Ohio that an operator under 451302, no person shall drive or move or cause or knowingly permit to be driven or moved on any highway, any vehicle or combination of vehicles which is in such unsafe condition as to endanger any person. Ohio Revised Code 4513.20, all brakes shall be, subsection 10, all brakes shall be maintained in good working order and shall be so adjusted as to operate as practicable with respect to the wheels on opposite sides of the trackless trolley or vehicle. This has been long-standing law in Ohio. Back in 1965, in the case of Spalding versus Waxler, the Supreme Court held proof that in this case it was the operator, exercised ordinary care in maintaining the brakes is not sufficient to constitute compliance. If the operator has not maintained the brakes in such a condition that they are adequate to control the movement of and stop and hold his vehicle, he has failed to comply with the brake equipment statute. It's almost strict liability. It is no legal defense to say my brakes failed. If you don't maintain your brakes and they are not working and you fail to maintain and ensure clear distance, you're liable. This is the city of Brunswick operating a common carrier for the residents in the city of Brunswick. They are held to the highest standard of care.
And yet your complaint sounds in negligence, so that their activity was below a standard of care.
Correct, because that's what the standard of care is. Even for a common carrier, it's still negligence. We're not suggesting that they were in any way reckless, but they had a duty to exercise reasonable care to maintain their brakes. There was a brake failure on this bus 2 months earlier. Mr. Scafidi has testified, and it's clear throughout the contract that the city of Brunswick is responsible for maintaining those buses. If the buses are out on the roads and their brakes are not working, they're responsible for it. There's all
to the point that Mr. Fisher is making regarding the immunity statute, are you taking the position that because I can't recall his name, but the gentleman who had been outsourced, the maintenance agreement, because he is not a city employee, that the city does not have the benefit of immunity?
I believe what the city has maintained is that Mr. Rake, the independent contractor who was repairing the buses, I'm not sure, they're suggesting that he didn't do anything wrong. I don't know that he did anything wrong. To be quite frank, I don't think I have to establish that anything was done wrong if those brakes failed and it caused a motor vehicle collision. Mr. Scafidi has testified that he was in charge of the BTA during the time of his tenure as service director for the city of Brunswick. He has a responsibility to make sure that those buses are maintained and safe. Mr. Rake may have done something wrong. Perhaps he should have been joined by the city for some indemnification claim. But I don't think the plaintiff has to join in an independent contractor for the city when the contract and the law is clear that the city is responsible for maintaining those buses and the brakes on those buses. And if they fail, the city is responsible for that.
But my question goes to the assignment of error, and that is that the Medina County Court of Common Pleas erred by denying the defendant the benefit of political subdivision tort immunity as to count 2 of the amended complaint, the negligent maintenance. So I guess what I'm asking is, what is your theory as to how the court properly denied the benefit of political subdivision tort immunity?
I think there's 2 issues to that. Actually 3. Again, going back to the statute that I referenced about brake failure, the statute says that no person shall drive or move or cause or knowingly permit to be driven or moved on any highway and vehicle. So we've got a couple of things. We've got Crystal Schemrich, which this court has previously said there is a question of fact as to whether she was an agent of the city at the time she was operating this bus. It's very clear that if you're operating a bus and the brakes fail, that the maintenance issue with respect to the bus, you can't say, well, we did everything proper to maintain it. You can't show negligence. Negligence is virtually presumed at that point that you did not properly maintain the brakes on that vehicle. Similarly with the city of Brunswick, under the contract and the testimony of their own service director, they were responsible for maintaining the bus and maintaining those brakes. If the buses were not maintained, then the service director was negligent in allowing this operator to take that vehicle out on the road. Somebody has to be responsible within the city of Brunswick. You can't just have this bus operating, which is what is typically happened on both of these appeals. In both cases, the city of Brunswick wants to say, well, we're not responsible for anything. We're not responsible for the drivers. We're not responsible for the maintenance. Of course they are. It's their bus system. They're responsible for everything other than the employment of the drivers. They can't just put this system out there, wash their hands of it when somebody gets injured and say, well, it's not our responsibility. The testimony and the contract are clear that they are responsible for the bus system. They are responsible for administration of the system. They are responsible for the maintenance of the buses.
And while they may be, you still have to get around the immunity, I think, which goes, I think that's why there have been a couple of questions about the issue of employees. But if there's no issue amongst the parties, unfortunately, the trial court's order doesn't tell us what material issues of fact were made, such that summary judgment was not proper. So I think the court struggles with trying to understand what the party's understanding is of where that might be. Because we don't make those determinations on the first instance, so.
Right. Your Honors, all I can do is set forth what our argument in this case was. We avoid the immunity statute if there was negligence by an employee of the political subdivision. In this case, the negligence by the employee of the political subdivision would be A, Crystal Schemrich, where there are questions of fact as to whether she was an employee operating a vehicle which had faulty brakes. B, the service director of the city of Brunswick allowing its, regardless of whether it's its employee or it's the employee of Medina County Transportation Authority, permitting them to operate this vehicle with faulty brakes. You know, there are issues with respect to Mr. Rake, but to be honest, I don't believe that was ever argued before the court. I think the other two issues are clear though. When you look at the statutes, if I'm driving my car and I hit somebody and my brakes fail, I can introduce all the evidence I want that, well, I properly maintained my brakes, but under the law, those brakes are not properly maintained because they failed. And the operator or the person who knowingly permitted that vehicle to be operated on the highway is responsible for failure to maintain those brakes. In this case, we have additional issues where the city service director knew that there were brake problems prior to this accident and the brakes fell. So clearly the city, through its service director, who has testified that he was responsible for maintaining this bus system, had knowledge of the problems with these brakes on the buses, and this accident still happened. That's all I have.
Thank you, David.
Okay. So Sam
You
Scaffidi's
have
an
just
issue.
under
Yeah.
5 minutes.
Okay, thank you. So Sam Scaffidi's an issue. He's no longer the service director. When his deposition was taken, he had been removed as service director, and if the whole case is going to be on the testimony of a disgruntled service director, Mr. Scaffidi, they're going to fail because the testimony isn't as represented to you by appellant. It's the responsibility, and it's right in the brief on page 3 of plaintiff appellee's brief. He cites the testimony of Mr. Scaffidi, and it's much different as cited in appellee's brief as represented in oral argument this morning. It's the driver's responsibility to inspect the buses on a daily basis. That happened. Crystal Schemrich inspected the bus. She did the test. The brakes were working. The engine retarder was working on the morning of May 22nd. That's how the city becomes aware of issues, because it's the driver's responsibility on a daily basis to inspect the vehicle before it's placed on the public roadways. That happened here. And Mr. Scaffidi didn't say anything other than the fact it's the driver's responsibility. Was there a problem with an air valve in the line of the brake lines? Yes, 2 months before on this bus, B12. It was replaced. The point, Your Honors, is this, that on the morning of May 22nd, 2010, morning of the accident, everything was done properly. The inspection was done by the driver, Crystal Schemrich, and Your Honor, it's not Your Honors, it's not collectively, it's not an issue of whether she was employed by, at this point, Medina County Public Transit or the city. She's the bus driver driving the city's vehicle through this 2009 agreement that's still in place with Medina County Public Transit. So clearly the city's responsibility on count 1, and it's not an issue, okay? The vehicle, obviously the brakes skidded, they did engage. When you take your foot off the gas, the brakes should engage with the engine retarder. That didn't happen. She had to pump the brakes, and the brakes did engage, causing a skid. Okay, that was a problem. She was unable, again, not because of negligent maintenance, because apparently the way it worked, she was unable to keep the vehicle from striking the vehicle of the bus from striking the vehicle of the excuse me, I'll slow down a little bit. The vehicle of the plaintiff appellee. No question on count 1. The city is not shirking its responsibility. It was an accident. There's a violation of assured clear distance. There's nothing other than negligence. As to count 2, I'm glad that it was pointed out by appellee. It's not reckless. They're claiming negligence. And there is immunity for the negligent maintenance and repair in this instance here, because there was nothing done improper. The burden is on the, in this case, plaintiff appellee, to establish that there is an exception under 274402B2, okay, to the governmental immunity protection that the city of Brunswick has as it relates to count 2 only. And that becomes the issue. The statute is not strict liability. Every time there's an accident that involves a problem with brakes, it doesn't mean that there's also automatically, as a matter of law, an issue as to maintenance and repair of the brakes. The city did everything that it could be expected to do, okay, to maintain and repair the 3 vehicles. And granted, they're older vehicles.
You have 1 minute.
Okay, but the city met its responsibility to the public, which the city of Brunswick takes very seriously. Okay, again, this isn't a question of hiding. It isn't a question of trying to avoid. But the facts are clear in this case that in terms of what happened, the vehicle was inspected before it went in service on the morning of May 22nd, 2010. The engine retarder did not work. Immediately after the collision, the independent contractor, or that matter, the city's representative, George Rayak, came out and did a thorough exam, and the brakes and retarder were working, drove it back to the station in Brunswick, talked to other drivers, never a problem that whole week with the brakes on this vehicle. It didn't apparently work according to the driver, Crystal Schemrich. The retarder didn't, engine retarder. It caused an accident. The city accepts that, okay? We accept responsibility on count 1. It's count 2 where there's immunity under 274402. Thank you very much.
Thank you,
Yes,
gentlemen. Thank
please.
you both for
Thank you.
your presentations. Court will take the matter under advisement. We'll issue a written opinion which will be sent to both sides. And do check the Supreme Court website as we issue our decisions.
Thank you very much.
Have a good day.
You too.